because I've lost my thing. Good morning. It's still morning. We are here to hear oral arguments in the case of Christopher Paulson versus Trishna Paulson. Counsel, I know you've both been here many times, and I'm assuming you don't have any questions about how our oral argument calendar works. But if you could please enter your appearances for the record.
Rodney Parker representing the appellant, Chris Paulson.
Julie Nelson and Aaron Harris representing Trishna Paulson.
Thanks. Just a reminder, council, that we are live streaming, I think, this session. And if you could please enter your appearance every time you take the podium, that just clarifies for everybody who is speaking and who is presenting argument. And with that, Mr. Parker, please proceed.
All right, may it please the court. Rodney Parker representing the appellant. I would like to, let me just tell you kind of what I have in mind today. I'd like to discuss the issue of the expert disclosure. I would like to discuss the summary judgment on alimony, unless I look down here and there's 3 minutes left, and then I'll skip that. And then the property summary judgments in the remaining time. So that's kind of what I have in mind, and leave the other points to the briefing unless you all have questions, of course. Turning to the expert disclosure, there are two issues here. The first is the adequacy of the disclosure, and what Rule 26 really requires in terms of the content of that disclosure. And I think that, of course, we've briefed that pretty extensively, but I wanted to give an example here today because I thought it might be helpful and to put it in context. And what I want to talk about is the fact that the same rule language applies to a rebuttal expert report. And I have this problem in a case that just kind of came up, and I thought, well, yeah, this is an important point. We, in this other case, a big divorce case, we knew the other side was doing appraisals, a business appraisal, real estate appraisals, we knew that. And so we decided, well, we'll see what they come up with, and then we'll decide if we agree or if we need to rebut it. So we wait, they give us the disclosure of the expert. We elect to have a report. We get the report and then we go through it. Now that's has started the 2-week clock ticking. So the clock is ticking. We go through that report. We decide, yeah, there are some things in here that we need to address that we're concerned about. We also felt that we needed to have new real estate appraisals on a couple of the properties, but not all of the properties. And so then our turn to disclose comes around in Rule 26, and we disclose what we're doing. But we don't know numbers. We can't disclose a number. We can't disclose the expert's opinion because we don't know it yet, because we've only had 2 weeks to deal with this question. And so we disclose who it is, what they're doing. You know, everybody kind of knows what's going on. And of course, then we get the inevitable objection and a request to have a written report, which that is actually in process now. But it shows you that what Rule 26 says needs to be considered in light of practice and how things actually work in the the real world of litigation. The rule seems to suggest that you can't disclose until the work is done. But the actual number, because the work at the time of the disclosure is not done. The opinions are still to be formed. It anticipates that. So it's a problem. So people do the best that we can.
But isn't that a sort of a tension in the appellate courts these days?
What?
Isn't that a tension that's kind of floating about here in the appellate courts? I mean, the plain language of the rule requires certain things, and we have been told sometimes that, or we have told you.
You're the tellers.
I was going to say, we have told you sometimes that it is the plain language of the rule that matters. We don't necessarily put a judicial gloss on rules or statutes, right? So help me with that.
Well, there is that ambiguity in the statute, or in the rule. I mean, it says the opinions expected of the expert and the materials the expert is expected to rely on. Not that the expert has relied on and the opinions that are already formed. And, I get that in the, the other side in my example case had a year to come up with that. We had 2 weeks. And so we couldn't, and it's the same language. And so it must incorporate the ability to get the work done.
And
But-
here, Mr. Townsend was the rebuttal expert, right? Or
Yes,
yeah.
No, he was not the rebuttal
No,
expert.
he wasn't the rebuttal.
The original expert.
He was the
yeah.
original expert.
And so anyway, let me turn to the issue of harm, because I think that is the real
Can I
issue.
ask a question? Are you
Sure.
suggesting, because the rule does say a brief summary of the opinions rather than expected, but it doesn't say a brief summary of the topics. And what was disclosed here were topics. And are
True.
you suggesting that there's enough ambiguity there that we can have expected opinions mean topics?
I think in this context that there is, because, if you're talking about a negligence case or a product case where there's a product defect, I think it's a little different. We're talking about a number, then the question is, when does the expert formulate the number? In this case, what happened is Mr. Townsend was still waiting for some answers to come back from subpoenas. And so they couldn't finalize it. That's my understanding of what happened. And so they didn't actually have a number until 3 weeks later. But
Was he in a position that he could have said what was in the financial disclosure, but then have an expert stamp on it, kind of, which is, we believe, his opinion would be, it will be at least this amount?
Well, good luck getting an expert to actually do that, because they
want to see
then
the
they'll be
data.
cross-examined. Well, you said you'd judge this before you'd even,
Sure.
So
Okay.
it's just a problem. In this case, and maybe you don't need to go there in this case because of the harm issue, because the harm here that was alleged was self-inflicted. It could have been remedied. The harm can't be the disclosure itself. It has to be, it must cause other harm. It must mean that the other party is unable to present their case or develop a claim or defense, or it impacts their ability to do that. And all of the cases that are cited go to that issue, a disclosure, the blank case, and a defect expert identified a year after expert discovery closed, RJW, 4 days before trial, Butler, 3 years after the end of fact discovery. There are obvious harms to go to initial disclosures after the end of fact discovery. There's obvious harm in those cases. But here, this all happened in a span of 3 weeks. There was no trial date. There was not going to be a trial date for a long time. It was the middle of COVID. And so it could easily be cured.
There was a summary judgment motion that was filed, and so is it appropriate to classify attorney's fees that were spent on filing a summary judgment motion before the report was produced? Is that harm?
I don't think so, because harm is harm to your ability to deal with the merits of the case, not attorney's fees that you spent. That's self-inflicted harm. That's part of the self-inflicted harm here, that they made a strategic choice, and the court called it that. The court said, see, where do I have that quote? That she made the strategic decision not to depose or ask for an expert report. Instead, she filed that motion for summary judgment, judging that doing so would cure the deficiencies in the disclosure. Well, that is an admission that it was self-inflicted harm, or that there was no harm. And Trishna described it as making a choice so as not to open the door for Chris to correct this error. So how is that anything other than then self-inflicted harm, the circular tautological harm, just comes from the disclosure itself rather than from the consequences of the disclosure. And the court never looked at that, never even considered it. I think that is an abuse of discretion. Now, I am not only past 3 minutes, but down to 1 already.
We've had questions and
It goes
I
fast.
want you to turn to the
Property?
property
Yeah.
division.
I
Yes,
will
please.
briefly discuss the property, although it's complicated. There are 19 summary judgments. They're not all factually exactly the same, but they do have factual similarities. There is, that Christopher managed a lot of these financial assets and properties. Title was taken in joint names. Some were in his sole name. And joint loans financed the properties. The prenuptial agreement is not as broad as Trishna claims. It does not include proceeds. It talks about present income and that sort of thing. It doesn't talk about proceeds. That's section 301. And may I continue? I don't
Oh,
want
yes,
to
please.
ignore the clock.
No.
I just saw it go to 0. Okay.
There's a lot going on in this case.
You
so
stop me
please-
if
Please go.
when it's time to stop, okay? It's not that broad. These interests were not acquired by reason of the marriage, which is, in other words, the marriage itself doesn't result, that's what the prenup says, doesn't result in converting property into community property. And it talks about property that's acquired during the marriage and says that it's separate only if it is acquired by either of the parties. That's 3.03. Not by both of the parties, and that's significant, and that's consistent with California law, that if title is taken, this is section 852A, I think, of the California Code, in both names, it's presumptively community property. And so that's kind of just the starting place here. You've got this method of acquisition, you have this commingling, you have, no attention really being paid to it for 30 years until divorce, and then all of a sudden it's, it comes up. So factually, there are these minor differences. I've tried to outline those in my brief because it's, there's a lot there.
I have a question about, and it's not in the brief, and so maybe I'm asking a question I shouldn't, but I wonder,
You probably should if it's not, that's the kind,
Sure.
right?
That's why we're here.
Section 7 of the antenuptial agreement that talks about further instruments. Excuse me. It requires each party to, well, maybe I'll just read it. Each party shall at the request of the other execute, acknowledge, and deliver whatever additional instrument may be required in order to effectuate the purposes of this, so that the one would have marketable title to any separate property. In my mind, this wouldn't be here unless you have contemplated that both names might be on a deed, but it's actually separate property. And so you're agreeing that, okay, I'll get it transferred to you so you can transfer
Oh,
it.
that's,
So how does that fit in with the scenario that you're talking about where you acquire it together with a presumption that it's meritable? But this seems to imagine the scenario where you might acquire it together, but it's separate.
because the prenup defines certain things as separate property. For example, I think it's a little hard to get a handle on, but earnings that aren't cash salary, for example, that is something that remains the separate property of a party. And if that is then used to acquire property, and either I guess maybe if it comes in joint names, or if, I think more likely what happens here is that especially in a community property state, it's, community property.
So
And
if clearly you had one spouse's separate cash being used to purchase property that gets titled in both names, that's traceable and you'd say that's separate property?
Traceable is the key word there,
That's
yeah.
okay.
Yeah, and on the traceability issue, the trial court, went with this exhaustion tracing theory from California, but really, seriously misapplied exhaustion tracing. Under California law, you have to look at the moment of acquisition of the property and say, okay, at that moment, was community property exhausted in the account that was used, to pay for it? And if it is, then you can use exhaustion tracing. Well, that did not happen here because there were not records to establish the balance in any account at any time that mattered in this case. And so the court said, well, overall, they spent more than they made in cash salary during the 30-year marriage. And therefore, we can use exhaustion tracing in that sense. But California rejects that proposition, specifically in the C case, holds that that's called recapitulation, disapproves of it because of the risk that it places on the disadvantaged party, and then requires that the party who wants to rely on it prove that the commingling and the lack of records is not that party's fault. Well, that proof didn't happen here. It couldn't happen here. It was, both parties' fault, really, that there was commingling and that there were no records. But not, it didn't satisfy the requirements of California law for recapitulation. And not only that, but factually to take Christopher's financial declaration, which the court rejects in the summary judgment, and rely on it, and then a number for income that is just a number that isn't really, I don't know how they calculated that, in 2020, and say, yeah, but back here in 2002, when you, or 5 or whatever, when you acquired this property, we're gonna use that number and just assume that it carried back the whole time. That is not, that is not exhaustion tracing. It's not recapitulation either. It's just a hypothetical, and it was grossly misapplied. So,
Can I ask this is gonna seem like a really silly question, but at the end of the day, bottom line, Christopher never came forward with any evidence that this money, that $100,000 that was put into the brokerage account, that yes, for 16 years, I increased that money by my work on it. But that original seed money was his separate property. Don't we start from the basis that all the properties were bought, all the, other than his salary from the company, isn't all the seed money and all the monies Trishna's separate property from the beginning?
no, I don't think so, and I do
Okay.
think the trial court sort of adopted that type of view. Focusing on that account, that $100,000 came from the sale of a classic car that belonged to Christopher. But I don't think anybody went back to see where the money came from when they bought the car, or how that happened. But I think more importantly that and it goes to the next point I was gonna make, is this transmutation point, that when Trishna took money and deposited it into an account in his name, only his name, and knew that she was doing that, or took title in joint names, or put title in an LLC that was owned by both parties, or had Christopher sign on the debt, or, all sorts of different things that happened with these properties, that is transmutation. And those documents, we believe, satisfy the requirements of the prenup for a writing that evidences the transmutation of the property, the placing of the other party's name on it. It's not an accident when that happens. You don't need magic words, and it doesn't say that you do, but the trial court did think that was necessary.
Your reply brief makes the point that you're arguing that that's what the antenuptial agreement, section 6 means as a matter of law, but you also seem okay, not as your first choice, but that you acknowledge that perhaps there'd be some ambiguity there, and that we could identify that there are two reasonable interpretations and send that back for some fact-finding based on parole evidence.
Yeah, I don't think that I don't think that the interpretation that the trial court adopted here is a reasonable interpretation. I don't think it finds support in that language. So our position is it's not ambiguous. However, if the court feels that there is support for that, then I do think it's ambiguous. And that's what I argued in the reply brief, or at least what I was trying to say. Sometimes it doesn't come out that way. Okay, I'm way over my time. I think I've covered the points I wanted to, unless you have any more questions for me right now.
I think you can.
Okay,
Thank you,
thank you
Mr.
very
Parker.
much.
May it please the court, Julie Nelson for appellate Trishna Paulson. I'm open to any guidance you have about where you want me to go with this. Maybe I'll start with the property distribution. Judge Luthi, your reading of section 7, absolutely correct. It relates back to section 3.03. That's the correct reading. Judge Christensen Forster,
Before you move on
Yeah.
from that, though, if you can trace, do you agree that section 7 doesn't necessarily mean, doesn't say whether property acquired in both names is separate or marital, that you would need to do some tracing of what funds were used?
Well, hold on, let's back up. So there's two basic strands here, right? One is this commingling transmutation argument, and one is a tracing argument. The commingling is in 3.01. It says that no property will be acquired by reason of the marriage. And section 7 is about transmutation. It says it applies to all transactions. So we know from the prenup that transmutation applies to all transactions. Now, we also have the entire thread about tracing. And the judge addressed, those are the two legal arguments that are presented. There's really no disputed material facts. So on summary judgment, all we're doing is looking at these legal arguments. They waived or didn't preserve most of their transmutation arguments. And then the judge applied tracing to everything else. And so we have a tracing analysis on almost all of the properties. So I don't know if that answers your question. If not, maybe you can.
I think so.
Okay. So I want to talk about specifically, I want to talk about California law, because some new California law came up in the reply brief, which caused me to have to do kind of a deep dive into California law. And I now know more about it than maybe I wanted to know. But, there we go. So we know that from the prenup, we know that transmutation applies to all properties. In the reply brief, they try to say, well, actually, that's not true. Transmutation doesn't apply to all properties. That's wrong under the prenup, but it turns out it's also wrong under California law. They cite us to a statutory section that for some reason is not on my, 2581. They cite us to a statutory section 2581 and try to say that that overcomes the transmutation issue, but that's not true. There's a case that was cited by the trial court, is cited in our brief, called Bonvino. It's 241 Cal App 4th 1411. It's a 2015 case. And it tells us at page 1428, sorry, I didn't get to put all this in a brief, so I'm sorry I have to give you pin sites. At 1428, it says the transmutation statute, which is 852, applies to property transactions between spouses as well as to property purchased from third parties. And then at 1431, citing another case, it says, this appellate court recently held that the requirements of section 852 must be met to transmute separate property to joint title before the joint title presumption of section 2581 applies. So what we now know is that under the prenup and under California law, transmutation has to apply to everything before you're even looking at any kind of joint property analysis. So we're back to transmutation is the correct lens to view this through. They waived, didn't preserve almost all of them. They did correctly raise it for two properties. One was 371 or 731 Sunburst, and the other was the 3 parcels of real property. It was addressed, the trial court rejected it. None of the other properties actually have a valid transmutation analysis raised.
Were those the first summary judgment motions? Because one of the arguments that we got in reply is we did make the transmutation argument. It was rejected. We're not required to then raise it every time when it's already been rejected.
I don't know where they fall, but I do not think that is a correct statement of the law. It's very easy to include a sentence in your opposition that says, also we adopt our previous transmutation arguments. You can't just preserve something through silence by saying, well, I mentioned it as it relates to this other property, so therefore we're all supposed to assume that it also applies to this property. That's not how preservation works. You have to give the judge your argument, and they didn't do that. And in many cases, they actually affirmatively waived it. They said transmutation doesn't apply here. I have a nice list here. They did that for Jazz 100, the Jazz 100 for Wallachette, for the HOK account, for the Next Level Plaza, for 701 Sunburst, for North 40, for 2300 ACD, and for 3413 56th Street. In all of those, they waived it. Not just didn't raise it, said it doesn't apply. So that's out.
So, and I've not gone and read all of those.
That's okay.
But it seems like the one way to interpret it doesn't apply is this argument that we've now received that there's not transmutation happening here. You'd have to go to recapitulation or whatever, that it doesn't apply means you can't use it here.
That is what it means, but the trial court rejected that. The trial court said, okay, so transmutation applies to all properties. It applies to all properties. And yes, you've got a tracing issue, but then the trial court, so let's move on to tracing. But the trial court addressed tracing in all of the properties. So the trial court addressed tracing, said that there was direct tracing on 7 of the properties, direct tracing, and then also exhaustion tracing on almost 6 of those properties. And then there was 7 properties where the trial court relied on only exhaustion tracing. So I want to look at a couple of record sites. The first time that we did an exhaustion tracing is related to the personal property, also known as the vehicles. The motion for that has the exhaustion tracing at record 3324. And then their opposition is at record 4828, and they say not disputed for purposes of this motion. That's the tracing. Now they come into their reply brief, at footnote 4 of their reply brief, and they say we conceded the math. End of story. Like, what happened in that exhaustion tracing was that the judge and Trishna identified, well, every year we made our marital contributions were much smaller than our expenses, expenditures, asset purchases. And so I used separate property for all of that. She did it. They're saying we have to have the account balances of each date. That's not what California law requires, and I'll get into that in a second. So we have an exhaustion tracing that says at each year we made this much money, we spent this much money, therefore it's separate. And the trial court agrees with that at record 7219. That's the vehicles. That's the first time it happens. I would also like to point you to a motion on the Cuervo properties. This is a really hairy one, a really thorough, very thorough one. The motion for that, the exhaustion tracing part of it is at record 7337. I would point you to the whole motion, but especially that page, 7337. The trial court agrees with that exhaustion tracing at 7351. Those are some examples of the exhaustion tracing. Now, as I noted, they've conceded the arithmetic. That should be the end of the story. But they come in their reply brief and they introduce this recapitulation idea. And I say introduce. The recapitulation situation was not ever presented to the trial court in a way that the judge was given the opportunity to say, oh, I don't think this exhaustion tracing is thorough enough. We need to do more. Instead, they conceded the math. They say that they conceded. In their oppositions to motions for summary judgment, they say these facts are not disputed for purposes of this motion only, whatever that means, but it's not disputed for purposes of this motion only. They didn't present the recapitulation theory to the judge so that she could do it. So they didn't present it to the judge and they didn't put it in their opening brief. They come here and they now tell us what exhaustion tracing means. They cite a 1966 case called C versus C. We cited at the trial court and in our brief a case called In Re Marriage of Ciprari. It's 32 Cal App 5th 83. It's a 2019 case. It does talk about this C versus C case, and it does treat exhaustion tracing and recapitulation as synonyms. In fact, it has a whole sentence. Exhaustion tracing is sometimes also called recapitulation, family expense, family living expense, or family income exhaustion tracing. This is at 914 of the Ciprari case. Whatever the name, it attempts to trace a payment or purchase from a commingled mass to separate property funds by process of elimination, i.e. by showing that because all community property funds were exhausted at the time the purchase or payment at issue was made, separate property funds necessarily must have been used. That's the case that the trial court relied on.
And the language there of marriage of Cipriari still does talk about at the time purchase or payment at issue was made.
That's right.
But you do have to identify it as of a specific time and not as the marriage as a whole.
That's right. As I understand recapitulation now in my deep dive to California law, recapitulation means like the person died, we're going to go back and we're going to figure out how much money he made over his lifetime and how much money they spent, and we're going to decide. And that may not be enough. Now, interestingly, there are other cases that say it might be enough. Like California law is a lot more friendly to this tracing of separate property issue than the reply brief would lead you to believe. I put in recapitulation in Westlaw and sorted by date and started reading the very most recent cases back, like the five years back. You know, I'm thinking, I've got this 1966 case. What have they said in the last 10 years? Well, there was a case that came out in May of this year, Smit-Camp versus Smit-Camp, 2025 Westlaw. I'm not going to give you, 1540548, if there's a law clerk who's going to go look it up. It's the same thing. It explains that, recapitulation means this. It's not really our favorite, but if there's no other way to do it, then you may have to do it. But here's the kicker. That's not what happened in this case. In this case, they did exhaustion tracing. They said, in 2016, this is how much we made. This is how much we spent. In 2017, this is how much we made. This is how much we spent. It's not a recapitulation analysis. And even if it were, it's not clear to me that it would be incorrect under California law. It's certainly more granular than the recapitulation scenario I just described where somebody died and we go back and look over their lifetime. That's not what happened here. We've got a year-by-year analysis. Now, Mr. Parker seemed to indicate in his argument that what he really wanted was on May 29th, the balances of each of the accounts were these. California law does not require that. The judge did it correctly under California law. And if that is what they wanted, they needed to raise that in the trial court. They needed to object. They needed to not concede the math then or now. So our position is exhaustion tracing has been done correctly. California law is not represented correctly in the reply brief. The prenup was interpreted under California law, and what the judge did in those summary judgment motions was correct as a matter of law, and the summary judgment motions are correct. Do you have questions about that?
I'd like your take on the expert disclosure
Okay.
issue and focusing in particular on the claim that any harm your client sustained was self-inflicted.
Yes. The first thing I want to say about that is that the expert disclosure ruling was a Rule 26 motion to exclude. It's not a summary judgment motion, and that matters for the standard of review. The court's interpretation of the rule is reviewed for correctness, but the court's interpretation of harm is reviewed for abuse of discretion. And that's really important here, because the judge did talk about the harm. I would point you to her ruling, which is on 8784. And at 8784, the judge says, look, they've disclosed topics, not summaries. They're supposed to actually disclose summaries of their opinions. And at the time, the rule which we attached to our brief required the entire file. Certainly the entire file was not attached. Summaries of opinions were not attached. It was literally topics. Now, Mr. Parker talked about, well, this is different than a products liability case. No, it's not. If a product liability expert says, I'm going to talk about the cause of the accident, or an accident reconstruction expert says that, or maybe a treating physician is going to talk about the standard of care. You have to say what the standard of care is. You can't just say, I'm going to talk about the standard of care. Townsend can't just say, I'm going to talk about alimony, and then give Trishna's counsel the opportunity to go to a deposition and say, so what was it about alimony that you wanted to say? You're supposed to provide a summary of the opinions so that counsel can decide, do they want a depo? Do they want a report? What are they going to ask if they go to the depo? So back to the judge's ruling. So at 8784, she says there's topics, not summaries. At 87, and actually she says some type of sorcery would be required. This is great language. Some type of sorcery would be required to divine Mr. Townsend's opinion based upon what respondent disclosed. At 8785, this is important. The judge says that Townsend had adequate information, not just adequate, he had the information that he needed. That was raised today as a reason why Townsend couldn't get his report done. The judge rejected that.
I want to re-raise Judge Orm's question, and that is on the harmlessness.
Okay,
part.
so at 8785, she talks about the harm. And she says, in delaying meaningful expert disclosures, respondent has sandbagged petitioner with the substance of his claim for alimony after discovery has closed. She says there was harm. And the harm is that expert discovery closed without there having been any sort of testimony. Without there having been any disclosure of opinions. And I want to back up while we're thinking about harm, because we've got inadequate financial disclosures that don't tell us what they think their alimony needs are. We go to Chris's deposition, he can't tell us anything useful at all about what his needs are. And then Townsend's report comes out and it also doesn't tell us what their opinions are. So we've got 3 times that they've had the opportunity to tell us what their opinions are and they've failed. So we file a motion for summary judgment saying, you've failed to provide us any information that we need. Now, we don't file a Rule 26 motion first, right? We file a motion for summary judgment first. And in their opposition to the motion for summary judgment, this is fascinating. In the opposition to the motion for summary judgment, which was filed on August 25th, 2021, they say, haha, gotcha, Trishna chose not to elect a depo or a report. Now she can't do a rebuttal. Now she can't do anything. She's locked out. Like, they say what the harm is right there in their opposition for the motion for summary judgment. It's not until we then file a Rule 26 motion that they backpedal. And they say, well, wait a minute. We could have reopened expert discovery. We could have, we'll give you the stuff now, and then you can take a deposition now. The judge said no. And under RJW Media.
Doesn't this come down, though, to the appellate bench making a decision between holding people strictly to the Rule 26 requirements, regardless of the fact that COVID is ongoing at this time, trial's not going to happen for years. The discovery can get done. You may be able to require one party or another to bear the other's attorney's fees for causing there to need to be additional work. But the case, by the time the case goes to trial, no one's going to be harmed, are they?
Well, I'm going to go back to the beginning of your question, which is, isn't that for the appellate bench to decide? It is not. It is for the trial court bench to decide. We're now in an abuse of discretion standard about harmlessness. The trial court said there was going to be harm. RJW Media and Bodell also say there's going to be harm. Now, I understand that there's been a concurrence by Judge Harris saying, oh, come on, I think you guys should lighten up a little bit. My phrasing, not his. That is basically what he said, but it's a concurrence and it's not a changing of the rule. The rule says what it says. We have appellate cases that explain that the rule says what it says, and it's up to the trial judge to decide whether there's going to be harm or not. And here the trial court decided there was going to be harm. Could the trial court maybe have gone the other way? I don't know. Maybe, because by then expert discovery had closed. The Rule 26 motion wasn't filed for months. If we had reopened, we would have been reopening discovery like another year. This case has been going on forever. The rules exist to try to move things along. I mean, if the appellate bench says, oh, I don't know, I think you should extend discovery.
Here's what I guess I mean by the appellate bench. For example, we do have our Supreme Court saying where the exclusion of an expert is tantamount to the dismissal of the lawsuit, which is the case here, at least as to alimony. The district court should exercise restraint in choosing this grave step rather than a lesser sanction. So that seems like our Supreme Court putting some bounds on that discretion that the trial court
I'm
has.
sorry, what case is that?
That is Corollas versus State, 2015, Utah 48.
Okay. So, first off, you said it was tantamount to dismissal. So they actually filed a motion to reconsider on this point, and I think that's important. It's not very raised in the briefing. We get the motion for summary judgment that includes the dismissal of Townsend. They file a motion to reconsider on this issue. It goes back to the judge. They give her all the arguments again, and also they ask to be able to go to trial even without Townsend, just on alimony. That motion to reconsider, if I can take a little tiny tangent and explain, because I think it helps. So the motion to reconsider itself is at 9627. They file a reply, or there's an opposition, there's a reply. The hearing on it takes place on July 6th of 2021. And that's important because it relates to the disqualification motion. They waited until that hearing and then filed the disqualification motion the next day. That's why that hearing is important. And the minutes, the transcript of that hearing is not in the record, by which we have to assume regularity of the proceedings. The minutes are 10121, and they say the motion to reconsider the summary judgment motion on alimony is denied. We actually never end up with a ruling on it. And the reason we never end up with a ruling on it is because the disqualification motion was by then in place. What we do have is a proposed ruling, an opposition, and a reply, all of which gives us a pretty good sense of what was said. And the reply has a footnote in it that says, I'm not going to file a request to submit on this until the motion to disqualify is resolved. It never ultimately gets submitted, so there's actually no order signed on it. So we have no signed order on it, and they didn't include the transcript. But there was a motion to reconsider. So tantamount to dismissal, yes, but they gave the judge another opportunity, and she actually, at that hearing, trial counsel was there and said that, I thought maybe you would give me something to work with here, but you didn't. So I'm going to deny your motion to reconsider. So now we've got layers of abuse of discretion. You've got a harmlessness ruling. You've got a motion to reconsider ruling. Those both have to be reviewed for discretion. And we also have Supreme Court cases, the Bodell case, paragraph 37. The timing is actually the exact same. In the Bodell case, 2009 UT 52, paragraph 37, it says it was not until 3 weeks after fact discovery closed, same time period here. It was not until 3 weeks after fact discovery closed that Bodell served the Waite report on Bank One. The Waite report included 3 new damages theories. That was the same thing here. They did ultimately provide, it didn't comply with the rule, but it was closer. They provided a letter and some attachments from Townsend that, like I said, didn't comply, but was a lot closer than just.
It wasn't like a full report.
It wasn't a full report, but it was
Close.
similar to a full report, yeah. But it had new information in it, right? It had new theories in it, new things. It would have required reopening discovery in order to deal with it. So the Bodell case carries on. Though the district court could have reopened fact discovery to allow for these theories, the court was not obligated to do so. The finding of prejudice to Bank One and Robbins was correct. That's the same thing that's going on here and that the trial court is relying on. So I think that's the answer to the question on the harmlessness. Do we need to talk more about the compliance with Rule 26?
I have a question about, if you could just address, and I know it's in the briefing, but would just like to hear you address it here, that why summary judgment should have been, let's say Townsend is excluded. But Trishna had put some numbers in the record about marital standard of living, and numbers could be imputed to Christopher as far as income. Why a summary judgment motion shouldn't fail based on the fact that there is evidence that could be disregarded or accepted, but it's in dispute, the numbers are in dispute.
Okay.
Does my question make sense?
It makes perfect sense, and actually it reminds us that the exclusion of an expert isn't tantamount to dismissal of an alimony claim, because you don't actually need an expert to deal with an alimony claim, right? And we know that even from their own, I mean, we have divorce cases all the time where we don't have an expert on alimony cases. People offer their own analysis. So back to the question about, is it tantamount to dismissal? It's not in this case. It's just getting rid of an expert. Like, the alimony case could have gone on. And had Chris actually filed his financial disclosures or answered anything at his deposition, it would have gone on.
Sure,
So-
but my question is, there
getting
was
to your
evidence in the record that a judge could have, at least this is the argument, there's evidence in the record from which the court could make a decision on alimony, weighing the Jones factors, and not weighing, but going through the Jones factors, figuring it out, based on evidence in the record. So why should there be a summary judgment against any alimony?
Right. So again, I would point you to the motion to reconsider, because this was discussed. The fact that you can actually use Trishna's numbers is discussed in the motion to reconsider. And I think that's helpful information, because the summary judgment did not really go into that line of cases. It followed the line of cases that focuses on the fact that somebody has to prove their own needs. They have to actually carry their own burden. So we go to the motion to reconsider. We see this argument that, well, but you could have relied on Trishna's, and the trial court rejects it. And the trial court rejects it on the basis that you've got these 3 strikes, you're out. Like, you didn't do your financial declaration, the commissioner told you it was confusing, I can't use that. We go to the deposition, you don't do that, you don't tell us anything useful there. You have presented no evidence. You have carried none of your own water. And alimony is a burden that
So it sounds like the short answer is that you have to meet your own burden.
you have to carry your own burden, right? And let's think about how this plays out in real life. If you don't have to carry your own burden on alimony anymore, you can file blank financial decks, you can give nothing at the depot, you can have no expert, you can go to trial and just lean on the other spouse's numbers. What incentive does that create for the other spouse to put correct numbers in? Nothing. That creates an incentive for the other spouse to say, oh, our needs are 50 cents, right? An alimony person, a person seeking alimony has to carry some burden, even under those cases that like are kind of squishy, kind of allow you to lean on the other side. You have to carry some burden. And so, like, I was looking back at the Munoz Madrid case, the Zhao case, and they both talk about there has to be some evidence in the record. You still have to carry some burden. And the trial court basically said, like, you haven't carried any burden. You've had all these opportunities, you haven't carried any burden. You have to carry your burden. And so therefore
And so you're saying by carry your burden, even though I'm not aware of another place in the law where we say this, that even though there's evidence there that would meet your burden, if you didn't place the evidence there, doesn't work.
Right. Yes.
Okay.
So with that, we would ask you to affirm unless you want me to talk about anything else.
Can I just ask a quick question about the disqualification?
Sure.
If Judge Johnson should have identified this potential conflict, if she should have and didn't, and it was, doesn't Christopher still have to show an actual conflict, that the representation by DJP presented an actual conflict? Even if she should have disclosed that she was represented by Mr. Thayer earlier on.
If I'm being completely candid, I don't know the answer to your question.
Okay.
But what I do know is that the presiding judge even said there was no appearance of bias. Not only that there wasn't an actual conflict, that he didn't even try to show that there was an actual conflict. And also that there was no appearance of bias. And also the the presiding judge knocked it out because they sat on their hands and waited until after that motion for reconsideration of the alimony. They had the disqualification information in the weeks leading up to that. I mean, even setting aside that actually Jones Waldo had known for like 2 years, this particular lawyer had that information in the couple weeks leading up to it and waited until after the motion to reconsider was denied, filed it the next day. And the presiding judge said, you sat on your hands, and they didn't challenge that in their opening brief. They've never raised that. And so I would say on that ground alone, then this court can affirm. Thank you.
All right, for the record, Rodney Parker again.
Thank you.
I'm surprised I remembered that, actually. Let me, that's a lot.
To do it, or that's your name?
What?
To say it, or that's your name?
Yeah. I still remember my name. Starting, let me just go backwards up these notes. On the disqualification, to your question, Judge Christiansen, or what we used to call you. Speaking of remembering names.
Right? I don't even remember my name.
The question was not whether Chris should have to show an actual conflict, but an appearance of bias. And I just wanted to say, I think that is a different standard. I do think he had the burden to show that, or at least to raise it to a point where, the presiding judge could, evaluate it. And, but it's appearance of bias, it's not actual conflict. And Chris didn't have access to all of the information that would permit him to really, unpack that.
Can I follow up on that just very briefly?
Uh-huh.
At the time, an appearance of bias should have required recusal, but at this point on appeal, if we were to say, yes, there was an appearance of bias back then, we wouldn't remand to make any new decisions, though, unless there was actual bias shown at the time of any particular decisions. Is that correct?
And I guess that was my, Judge
Is that what
Levy
you were-
articulated my question much better.
Oh, okay, yeah, that is, I think, yeah, that's a hard question to answer. I would say that, and I think I'd like to see this happen if there is a reversal in this case anyway, a new judge assigned. But then, but if it had happened the way you're describing, or it happens the way you're describing, there would be a new judge assigned, and then I think it would be, we would go to that judge and explain, okay, these are the motions, these are the issues, basically reconsider.
You'd move for reconsideration.
Right.
How, on that
'Cause it's
second,
not law of the case, of course.
sure.
so.
On that second point, though, at this point, years out, what would be the basis for us saying there needs to be a new judge now, where there's not been an argument that she was actually biased, and at this point, there wouldn't be an appearance of bias this many years later. She's no longer represented by, is it Durham Jones? On what basis could we say, assuming that we remand for other reasons, and on remand, you need to assign a new judge because why?
Yeah, well, because of everything that's happening here and the finger pointing and at the judge and the things that we've had to say. But, I don't know exactly how to answer that. I will tell you in in the federal system, if there's a remand and a reversal, they automatically reassign because of those concerns. Is this judge going to harbor some resentment because of what happened on appeal? And so they will reassign. And I don't know that that's necessary in every case. I think in this case, there is enough there that it would justify that. But I think that is a judgment call for sure. Turning to the reliance on Trishna's evidence, the alimony claim. First of all, it is tantamount to dismissal under Corollas because of the circumstances, and that's described in the briefs. Christopher didn't pay these bills, he didn't really know, and so he couldn't give numbers, and so that does put him in the position of tantamount to dismissal. Now, he still was able, sort of in a handicapped way, to do what they did in the Kawasaki case, which is to rely on the other person's numbers. He also, and I think he could do that. And I think the point you were making, Judge Luthi, which I think is correct, is that was some evidence. And this is summary judgment. And so, this isn't discretion. In Kawasaki, it was discretion. It was after a trial, it was different. Summary judgment, there was some evidence. He also could have testified to describe the lifestyle, to support, numbers along the lines of what Trishna said the lifestyle cost. He could have done that. And I do think that on summary judgment, that should not have been precluded. Going to the question of, can I continue or?
Yes, please.
Okay, I'm sorry, I don't mean to, like I said, ignore the clock. Still working backward, going to the question of harm. I wanted to say that the definition, it was argued that whether there's harm is under the abuse of discretion standard. I don't agree with that. I think that the definition of what is harm is a correctness standard. Is this harm or is it not harm? That's, if you go back to Corollas, that's what's going on. I briefed the Corollas case. I was on the short end of it at the end, but that was the issue in Corollas, and they said they were not willing to find that there was sufficient harm to basically impose what amounted to a terminating sanction. We were arguing that these experts had been exposed to those internal investigation panel reports. I can't remember what they call those, but and therefore were tainted. And so they couldn't testify. I think everyone agreed to that, but could they be replaced? That was the question. And so they're looking at harm, and I do think that it is incumbent on this court to define harm. Was expert discovery closed, as has been said earlier today and in the brief? No, it was not closed. Expert discovery was just starting. We were, at the time that the full Townsend report came out, 3 weeks after the beginning of expert disclosure, not the end of it. The thing that was closed was that first deadline, that 7-day deadline. That's the only thing that was closed. And to go back and say, okay, 2 weeks and reopen it, especially in context, that is not harm. That is not harm. Harm is, how does that preclude a party from presenting their case? To go back and allow the first party to file that report, that full report, 3 weeks after the deadline. How does that prevent Trishna from presenting her case? And can that issue of what they're relying on as preventing it be mitigated by saying, well, you can do you can go ahead and do your own expert anyway, even though
Wouldn't then there be some discretion in determining what kind of mitigation would we allow? That if we're at 2 weeks before trial and we get the information that we need, well, if we extend, then we don't have another trial date for a year, but let's set it out for a year and you're not harmed. That seems like a court should have discretion to say, you know what, we're too close. But in
Right.
another case, perhaps here, look, trial's not gonna happen, we all know, for some years. But give the trial court some discretion in terms of
Yeah.
when you allow additional time.
I agree with that.
And
I
it seems
think
like
this is,
Bodell may instruct us that there's a fair amount of discretion there.
it reminds me of the Pena case, which is the cattle enclosure or whatever,
Judge
you
Jackson.
know. And within the fence, within the enclosure, yeah, I think what you're saying is true, but you're still in a position to define if you're outside, if the trial court's outside the fence. And I think that's what I'm arguing is here. And given the way that it's described, she chose not, she made a strategic choice in those sorts of words. Those are not words of the type of harm that is contemplated under these rules. Those are words of self-harm. There would be no reason to reopen discovery, fact discovery, and we're just right there at the expert. If there's a reason to reopen fact discovery, it existed anyway, right? Because it didn't just come up because an expert report was 2 weeks late. That's not, that doesn't make any sense. And Bodell is a reopened fact discovery case. I don't know exactly what the facts of that case were, other than what was just described here. But reopening fact discovery is different than what we're talking about here. And then finally, on the issue of transmutation, I have to put these on because I really scribbled this. Really, I think the argument is being made here that the transmutation argument was waived, and our response to that is you don't have to keep saying it over and over again once the trial court has, ruled on it. The question isn't, preservation isn't a matter of stating something in one sentence as what's described. That's like checkers. That's like once you take your finger off, you've made your move. But that's not what we're talking about here. Did the trial court have the chance to consider the issue? That's preservation. And here the trial court did have that chance and did not have to have that chance 19 more times. So once the trial court has considered the issue, and you see it in the if you look at those summary judgments, you'll see it over and over again. The trial court is repeating the transmutation and repeating the exhaustion tracing arguments, even though, early, and that's because early on, the court adopted that and just never changed. So I don't think that there's any significance to not putting a sentence in, oh, by the way, we don't waive this, because it's becomes part of the background. There were times when it was not applicable. And so when they said it was not applicable, I think what they were saying was it was because the property, it wasn't transmuted, it was always in Christopher's name. There's HOK account was like that. That was proceeds of car sales. The brokerage account was like that. It was in his name. Her name wasn't on it. There was no need to get into that issue because his name was the name on it. And that was the argument they were making at that point against the background of what had happened with transmutation in earlier motions. I don't think the trial court did any tracing that wasn't in the context of exhaustion. And it's always that we can trace it because of the exhaustion, which was simply misapplied, as I described earlier. And so it's this idea that there was direct tracing is not consistent with the trial court's findings. And the last thing I wanted to say is exhaustion.
This comes after your finally.
What?
You, a while ago, said finally, and now you're at, and the last thing I want to say, I'm just wondering when it's going to end.
Now, finally, the last thing I want to say is that exhaustion, there's a feedback loop here, because exhaustion tracing depends not only on these cash salaries, but also what else was in those accounts and how is it characterized. Is the money from HOK, is it separate, or is it marital, or is it Chris's, or whose is it? The brokerage account, because funds were used from those accounts. And so it isn't as simple as just looking at their salaries. These other issues come into play, and then you get this feedback loop that's very difficult to untangle unless you just go right back to the beginning. And I am finally done, Judge Warren. Thank you for your indulgence.
Thank you, counsel, for your arguments today and for your briefing in this matter. We will take the case under advisement and render a written decision as soon as we can. And with that, we will be in recess. Thank you.